Without the power of attorney, you can't open any business in Brazil. This power of attorney says the following: grantor shall hold the attorney harmless from and against any claims, losses, or damages arising out of or relating to this POA, power of attorney, including labor and tax liabilities. That's what is said in the power of attorney. But it has no effect to the Brazilian justice. You can write that, and if you don't make an assurance, if you don't pay the insurance to your attorney, all his assets will be gone. You must also pay an insurance to your attorney. Otherwise, the Brazilian justice will drain him out of his assets. And why is that? Because of the fiscal debts of your company and because of the demands of your employees in the labor justice. In the Brazilian labor justice, everything is for the employee and nothing is for the employer. If the employee demands something in the labor justice, he surely will win, even if he lies. Now I present you to the power of attorney. Power of attorney. By this instrument of power of attorney, the company, Chinese private company, headquartered in, here I'm represented by its manager, Mr. Brazilian citizen, married, passport number, domicile that. Hereinafter referred to as the grantor, hereby appoints as his legal representative Mr. Headquartered. Instead of headquartered, we could have written in that power of attorney having its principal place of business or having its registered office. The headquarter or the head office is the administrative center of the business, whereas registered office is where the business was registered, having its principal place of business. I think it would be better, it would be proper to say that. Hereinafter referred to as the attorney, to whom are granted all necessary and sufficient powers to. The grantor is handing to the attorney. A. Represent the grantor in the limited liability corporation of which the grantor may come to be quota holder, member or partner of any kind. In America, there is no quota holder. The correct word in America is member, which is to be organized under the laws of the Federative Republic of Brazil company. Being able to represent the grantor before the trade board of any state, with the powers to join the corporate structure of the company as partner, as well as to subscribe and pay up quotas on behalf of the grantor, and on its behalf attend and vote in ordinary or extraordinary shareholders, quota holders, members and or partners meetings of any companies and sign any and all minutes of such meetings. As I have said, there isn't such word quota holders in America. B. To execute applications for the incorporation of company, requests for enrollment of company, opening and closing terms of corporate books, articles of association, of incorporation of a limited liability company, including when these acts are practiced with the use of digital certification to be presented for authentication before the commercial registry of any state. C. To represent the grantor before any governmental agencies or authorities, any private or public entities, especially before the E1, Central Bank of Brazil, Bacen, and its Electronic Information System, SISBACEN, to enroll the grantor and any company in the registry of individuals and legal entities, residents and non-residents, enabling thereby any transactions and services provided by the Bacen, including but not limited to 1. Enrollment at CDNR, Financial Transactions Registry, Direct Foreign Investment, SSCEIED, of Foreign Investment in the Brazilian Financial and Capital Market. 2. Access to the regulation, currency exchange rates, economic indicators, and other information made available by the Bacen. E2. Any commercial registry of any state. E3. Commercial Registration and Integration Department. DREI. E4. The civil registries for legal entities. E5. The civil registries for deeds and documents. E6. Brazilian Federal Revenue Office, any states and municipalities revenue offices, especially with the purpose of enrolling the grantor and or the companies in the taxpayers registry, assessing any information regarding its debts, obligations, and registers before such entities, and complying with any other legal requirements pursuant to the Brazilian law. D. To receive service and subpoena for lawsuits, administrative or arbitral procedures and processes on behalf of the grantor, only and exclusively in the form and in the cases outlined in Article 119 of the law number 6404 from 1976 and in DREI Normative Instruction number 81 from the 10th of June 2020. E. Manage the assets and rights of the grantor in the country exclusively on the limits required to comply the Federal Revenue Service Normative Instruction number 2119 from 2022. F. At his discretion, to delegate all or part of the powers granted hereunder on the conditions that the attorney shall deem proper, and G. To sign an and all documents necessary and or convenient to practice the powers granted hereunder. Number 1. The termination or resignation of this POA shall only be valid if made in writing. Email notification shall be valid as proof. Termination or resignation will be effective upon receipt of the written notice by the other party. Number 2. Grantor shall hold. It's two words, shall and hold. There is a space, and they haven't put the space here. Grantor shall hold the attorney from and against any claims, losses, or damages arising out of or relating to this POA, power of attorney, including labor and tax liabilities. Number 3. This power of attorney shall be valid for unlimited term applied upon signature, executed on this date, place, by, represented by. It's over. We have just read power of attorney. Shortly on your screen, you'll see my Brazilian bar number and my email. Bye.